Yes, Mr. Das.
Lordship, with regard to item number 29.
What
can
do
it
you
be after
want?
3 weeks, Your Lordship?
3 weeks.
3 weeks, Your Lordship. Actually, sorry, couldn't circulate the adjournment request, Your Lordship.
You are for the petitioner.
I'm for the respondent, Your Lordship.
I am for
Have
the
you any objection?
No, no.
As prayed for by Mr. A. Das, learned counsel appearing for the respondent with consent from the other side, relist after 2 weeks on a date to be fixed by the registry.
Much
Yes,
obliged,
next.
No, please, Your Lordship. Lordship, I beg to mention.
One second, there's a senior counsel.
No,
Is it-
he's mentioning a lot. My
Acha.
I have taken the
So-
so.
Okay, yes,
I beg to mention item number 26 and 27, Lordship.
yes.
And it is matter I pray for adjournment for today, Lordship.
All right. Mr. Chalia, any objection?
Only a date has to be fixed, my lord.
All right,
After
Otherwise, matter is pending since 24.
all right. Someone will date to DD.
after 20.
As prayed for by Mr.
S.A. Bhatia.
S.A. So-and-so, learned counsel for the respondent with consent from Mr. D.P. Chalia, learned senior counsel, assisted by Mr. You just give
M.
your
M. Roy.
M. Roy, MS M. Roy, relist on such and such date. Yes.
I beg to mention item number 12, with consent of the other side, is the matter after.
I think you had already, item 12.
12,
Okay. You are for,
the petitioner,
as prayed for by Mr.
here, but
K.R. Patgiri, learned counsel appearing for the appellant, relist after 2 weeks on a date to be fixed by the registry. Yes,
Permission to mention item number 38 before court number 16, Your Lordship.
item number?
38 for court number 16, Your Lordship.
I'm sorry, I have not understood. What do you
Lordship,
want?
it is listed before court number 16, so the mentionings have to be done
Item 38.
in court number 16. The mentionings have to be done.
I don't recall. Mentioning the urgent listing of. That list is not before this court, Mr. Counsel. Mr. Counsel, please have a look at the notice. Please have a look at the notice. Yes, next.
May it please your lordship, with the consent from the other side, my lord, I beg to mention item number 5 to 7, my lord. My senior Mr. N. Upadhyay is in bereavement leave.
5 to,
5 to 7, my lord.
what do you want?
Matter may be passed over for 2 weeks, my lord.
For, you're for the,
I am for the petitioner.
who is on,
We are informed.
no,
the
no,
respondent.
sorry, I didn't get you. What did you say? Someone is indisposed?
No, yes, my lord. My senior Mr. N. Upadhyay.
Okay. As prayed for by Mr.
Yes, Upadhyay, my lord.
S. Upadhyay, learned counsel appearing for the petitioner on the ground that Mr. N. Upadhyay, learned leading counsel, and the matter is indisposed. Relist after 3 weeks on a date to be fixed by the registry.
Deeply obliged.
If we,
Yes.
Lordship, I'm paying for listing of IA for orders on Wednesday, Lordship.
Yes.
May I please, Your
I of which bench? Of this bench?
No, court number 16, Lordship.
Okay, yes.
May I please, Your Lordship. Lordship, I pray for listing a MSc appeal, Your Lordship. That matter has been settled.
Just one second. If any similar prayers for listing any matters of court 16, please give it to the court master. Dates would be given.
I'm sorry.
Yes,
The same listing of.
you just heard.
Yes, madam.
Give it to the court
But the
master.
matter is today itself. It is fixed for some urgency. It can come.
Miss Counsels, kindly see the notifications properly before you approach the constitutional court. Please be mindful of the judicial time. Yes, next. Anybody more? Yes, call the list, please.
May I please, my lord, I beg to mention item number 39. Kindly list the matter after a week.
39 of this court.
Okay.
Why? It's a hearing matter.
Your Lordship, in this case, I am appearing for respondent number 5, one of the respondents.
Yes, ma'am. Why you want time? You don't know. She's being very modest, Mr. Das. She's being very modest. But I think, Mr. Das, this bar, especially the new generations, need some training. I mean, we looked upon you all, Mr. Das. So I think you should do something. It's all right. I think because I've been noticing, it is not their fault because somebody has to tell them. So I think unless these responsibilities are taken by someone, it will not.
Right.
So anyway, as prayed for by MS.
B Sharma.
So and so, learned counsel appearing for the appellant, have you taken consent?
No, your lordship, they are appearing for claimant respondent.
And you are for?
I am for respondent number 5.
So who is for the petitioner? Appellant.
Appellant is the insurance company.
Have you taken the consent? With consent from the appellant counsel, relist on such and such, relist after 2 weeks on a date to be fixed by the registry.
Blank.
For admits on item 1 to 4.
Which is this matter? I have forgotten. It seems it's a part-heard matter.
Yes, yes. I can just refresh your lordship's memory what.
Yes, Mr. Kashyap?
Lordship, the matter relates to termination of contractual services of erstwhile employees of the Cotton University or Cotton College, as we call it. Lordship, what had happened is that all of the petitioners here, they were employed, one set was employed in computer science and IT, and the other set was employed in molecular biotechnology. However, they were rendering their services for almost a decade. Pursuant thereto, they were terminated from their service, and other people were given.
Just 1 second. Disturb who is it? Yes.
And the private respondents were given appointment to that. We are not aggrieved by the appointment of the private respondents, Your Lordship. We are just aggrieved by the simple, our services were not regularized. So in basic sense, this is a matter for regularization.
No, but on what basis were you appointed?
Lordship, we were based on an appointment that was issued, which was for a contractual period. We were appointed.
Then contractual, it was not by any advertisement.
Lordship, there was an advertisement for the contractual services. However, what had happened, Your Lordship, that advertisement was issued by the registrar, because the registrar back then was the highest authority, to my understanding.
But
Lordship,
that position must have been challenged by the respondent.
Lordship, on the last occasion, my senior Mr. Chaudhary, he had made certain statements, and our pleadings were thereby more or less done. The respondents were supposed to reply to that. So we were waiting.
Okay, then Mr. Das, you may
I just
recapitulate a little
Yeah,
bit
just
of the facts
respond.
and then start with
My
your.
lord, my learned friend, Mr. Chaudhary has shown some judgment of the Supreme Court.
Hmm.
Great respect. Judgment will come later on. Facts is very important.
Correct. And I
that's
have
what-
almost
what-
forgotten the
that's-
facts, so
That's what we have learned. Facts is most important than
Absolutely.
the judgment.
they will apply to the context of the facts.
Yes. My lord, there is a note which you have prepared, which note is important. Your lordship can just look into the note.
Yes.
This is of facts, my lord.
This is under 5 and 6 of the Assam Education Service Rules. Econ. Nahi, huh? Assam Education Service Rules. You are for the university? So after after the university, I think there has been some change.
Yeah.
So now you are not regularizing their services.
No, there is a decision taken by the.
There is a
by-
decision.
Decision, and that decision has been taken. My lord, that's what I'm saying. Facts is important. 2018, it is on record. It is on record. We brought it by filing an affidavit. There is a decision which has been taken by the council, executive council of
Yes.
the university.
Yes.
Now they have taken a decision. They said
Yes.
there is no question of any regularization these services, even if there is a contract, even if they are contractual.
Yes.
This is a decision which has been taken by the executive body of the council.
Which page shall I
yes,
find
I'll
this? Just
just-
indicate the page
I
right
will
now.
indicate only the page.
Yes.
That's
We'll
indicate
go
the
to the
page.
details little later.
No, I will just indicate the page without wasting much of the time.
No,
Yeah,
you
no,
can
just
take your
l-
time. I want to put it in the note.
It will just, it's page 70,
75.
70 of the
Sorry, sir, 70 is of the.
affidavit, kindly see, my lord.
Page 7,
affidavit, our affidavit.
70,
No, no. It is page 161, my lord. 161, running 161.
Okay,
And that resolution, your lordship, there is this is up to from 161 to 167,
okay,
where your lordship 167, they have taken a decision.
okay. At
Just
page 16.
4 lines.
Just read,
Your
read
lordship,
it.
don't open it.
Read
I'll
it.
just
Read it.
The letter number so and so after was received from Director Higher Education Assam seeking proposal to regularize the assistant professor contractual to Department of CSIGTCU. Matter was placed to a register for discount advice. EC suggested that all the contractual teachers appointed by Artsville Cotton College and Cotton College State University across various disciplines of the university be encouraged to apply against the advertised regular post. Selection and recruitment of teacher would be in accordance with the UGC regulation, Cotton University Act 2017, and their experience may be given weightage as per rules. So this decision has been taken. It has been communicated to the government. Your lordship kindly note down that page 168. Communicated to the government.
168
168.
to government.
Yes. And in pursuance to that, they decided to advertise.
That
They
is under
decided-
challenge.
Yes. This advertisement.
And that advertisement is which page?
Yes. Your lordship will find in the writ petition, they have advertised at page 63 of the writ petition, which they have filed. That is writ petition 938 of 2020.
938. no?
8 of 2020.
So this
which-
note is also in 938.
Yes, 938. So this is 63 they have advertised for this post. All 4 posts.
And this post is academic counselor.
No, that's the initially it is a principal. They have advertised. We don't have all the
No, this
advertised.
page 63 is advertisement is
No,
for.
there is no post as academic council. These are posts of assistant professor.
No, that's right. Right now, the challenge is page 63. So
63
that is what post?
assistant professor.
Assistant
Professor.
professor.
Yes.
Now tell me that initially they have been appointed as what?
Academic counselor.
They have academic.
Academic.
Now I'm remembering
Yes.
academic counselor. So because I think you are saying that there is no record of any such post
There
of
is no
academic
such
counselor.
post. There is no such post. Now, what I am on, my lord, very well, there are judgment which has been shown. Just now your lordship knows where to connect. Now, they definitely have come up and say there are judgment. We also know there are judgment of the Supreme Court.
Judgments are always both
Even-
sides.
even
Of
you
both
have-
sides in
Then
regularization you
have
find.
put on more than 10 years of service. Some type of yes.
Here, how many, how much time, how many years they have put in?
They
Almost
from
about-
2007, we have put a note, 2007, 2008, 2009, up to 2020, 31, 3, 2020,
31,
3,
3,
2020. They did not continue. They continued till 6th of February 2020, right?
Yes.
6th of
So,
February
2007, 2008, you said?
2008, from 2008 onwards. One
Not
second.
7.
No, your lordship will kindly see the note we have given. Page 3 of the note. Please see page 3 of the note.
No, I'm going to read this whole.
Yeah,
note.
yeah.
Ah, yes, yes, yes.
See,
7 and 8 and
Yes.
9.
yes. I think for the convenience,
Yes.
we made it.
Very well.
So,
Very well.
so this is what.
Okay, let me just quickly read
Yes,
this
quick,
note.
then your lordship will get it.
So this advertisement that they are relying at page 29 of the writ, that 2008 advertisement, Mr. Das, in that, what is the post mentioned?
Academic counselor.
And this other one, which I think is also there in page 114 of the affidavit of respondent 4 and 5, some notice, that is also academic counselor,
Yes.
no?
Yes.
Academic counselor ad hoc and
Yes.
academic counselor part-time.
Yes.
So this probably they are trying to show that this is not without advertisement. Yes, of course, that argument is, your counter argument is that no such post exists. But I think they are trying to show that,
Some type of.
yeah, it's not a pick and choice. It's not a pick and choice, but an advertisement was there. So this is the eligibility criteria.
As per UGC.
If I want to see this, where do I find this?
The
The UGC regulation, can you, Mr. Nair, can you just provide and just please write it on top, huh? Eligibility criteria and which regulation number. I may ask more documents, so you put a note right now. You give it later. So records of the selection process only shows one Dushanta Datta being selected.
Correct.
This Dushanta Datta is not a petitioner.
No, he's not a petitioner. Biswajit Das was one of the candidates in that selection process.
He is petitioner number
Petitioner number here indicates 5,
P5.
P5.
He was one of the
One of the
person
persons
who
in the advertisement,
participated.
but he was not selected.
Okay. Participated, not selected.
Not selected. Only Dushyant was selected. And his appointment of Biswajit Das, your lordship will find in the chart,
Yes.
is only 2/3/2009.
Yes.
Kindly see the chart.
Yes.
So in persons to that advertisement, he was not selected.
This 1, 2, 3, 4, that serial number indicates the petitioner's arraignment as well.
In the memo.
So 1, 2, and 3 does not have the requisite qualification.
1, 2, 3 has the requisite qualification only they acquired in 2015, 17 and 18. They at the initial stage. When they entered.
That time they did not.
They did not have.
Later they got.
Later.
That is in 17.
17, 15 and 1, 2018.
So generally that benefit comes from the date of acquiring, right?
Then even then 10 years is not been completed. Even we take one line of argument. 4 and 5 doesn't have.
They don't have.
Even as on date.
No PhD.
No PhD.
So salaries has been paid up to 31,320
Yes,
as per some order of this court.
yes.
Mr. Kashyap, you have got it?
Not-
You have got a copy of this, no?
The order, I do not have it.
No, but the
Copy.
notes.
No, your lordship.
Give him a
I'll-
copy.
I'll receive.
I thought you are having it because you are reading something.
No, lordship. I will-
Yeah, yes. Yeah.
Normally that's the first.
No,
when
you see, with you there, I took it because
No, no,
generally,
I-
yes, but.
I remember when he was start reading, he were under any senior first note should be on
Correct,
the other
correct,
side.
correct. So this petitioner number one participated in one of the selection process
Yes.
in the year 2013, and he did not qualify.
Qualify.
These cases are filed after being unsuccessful.
Unsuccessful. 2019 also, that advertisement.
Overaged.
Yeah.
What is WPC 9474?
474 of 2019, my lord. This is a case where there was an advertisement issued, my lord. The two of 2019, they because they doesn't have that qualifier 4 and 5, 1, 2, 3, they had the qualification, but 1 and 2 is was overage. So their particular they were out. So far as 3 is concerned, my lord, there has to be a cutoff mark. He also didn't satisfy the cutoff mark. He didn't satisfy the cutoff mark.
So
So
they-
1 and 2, 3
Hmm.
participated. 1 and 2 rejected on the ground of overage. 3 minimum cutoff mark he didn't have. So we rejected.
So that
And-
is under challenge here. What have they challenged in
This
9474?
is what they have challenged. They said after participation, they were not, my lord, qualified for Viva.
So selection challenge.
So they challenged that advertisement they challenged, and their whole case is that their services should be regularized. 9474. Their services should be regularized. They participate in the advertisement, and that
So the first 938 is only for that advertisement challenge.
9474 is the first where they challenge the advertisement and also regulation. Because
Okay.
they did not, because they were disqualified.
Okay.
I will use the word disqualified.
Okay. And 938?
What has happened 938? My lord, in the meantime, that selection, my lord, ended with logical conclusion, and there was the appointment which
So
was.
those have been put to challenge.
Yes.
Private respondents. Who is appearing for the private respondents?
Mr. Roy is appeared, Jyotirmoy Roy is appeared.
I remember he said you are no one is disturbing his position or something, right? And Mr. Gogoi, you are also appearing for the
This was the schemes.
council, UGC,
Huh?
hired.
I think he can enlighten more on this Cotton College at that relevant time when that advertisement notice was issued. Yes. Please.
All right.
This is my lord. I think, my lord, now we know the factual part, your lordship. No, there are two repetition, 9474, where there was advertisement, they challenged, they participated, they became unsuccessful, they came to the court and 9474 was filed, challenging the advertisement also, but their whole contention is they should be regularized. Now, the basic foundation of the case you want a regulation very well. Now, my lord, you have to see that whether you have challenged the decision of the council, executive council, which is of 2018, your lordship at page 161. You did not challenge that. So unless you don't challenge, you have to challenge that, no, our service has to be regularized. Your decision is wrong. You did not challenge that. Today, your lordship, let us say that yes, but where is that you challenge that decision of the executive? You did not challenge. This is number one. So unless you don't challenge it, where is the question of your being regularized, your service? Now we know, my lord. Let us connect this way. Regularization, yes. After serving a decade, what my learned friend said, yes, we also know you served decade. Initially academic counselor, redesignated as assistant professor. You came to the court in 2020 saying that your services should be regularized. Regularized has to be on 2-3 condition has to be met up. Now, whether you had the requisite qualification at that relevant time, your qualification of 1, 2, 3 is only on one is 15, one is 17, one is 18.
Yes.
If you count from that also, you did not have that 10 years. Number two, whether it was a valid sanction post,
Yes.
then only, my lord, your service for long 10 years may be counted. And that too, one-time measure, that can be a direction, request can be made to the state that they can take appropriate step by way of a cabinet decision to regularize their service. This is what I have understood the judgment of all the court.
Yes.
Now, my lord, there is a change of Umademi, your lordship knows. See, there's the constitutional bench judgment, paragraph 53. But now there are other judgment. Jago has come. Jago judgment has come also. Your lordship has looked into that judgment. Now, a trend has changed now. Now a bit of trend has changed.
Regularization.
Maybe a constitutional bench judgment, we respect constitutional bench judgment, but kindly see the judgment of Jago, my lord. So, my lord, ultimately, end of the day, my submission will be.
What is the citation?
Yes, Jago citation.
SCC online.
Yes, it is on SCC online. 2024
2024
SCC online SC 3826.
SSC online
SC 3826.
SC
SC 3826.
3826.
Yes. Your lordship kindly note down some paragraph, few paragraphs.
Yes.
I have wrote those paragraphs 8, 9, 10, 19, 20.
One second, Mr.
Yes.
Das. 8, 9, 10.
10, 19, 20, 26, 27, and 28.
You said some paragraphs. I thought it was very few. No, I understand. On a lighter note, Mr. Das.
Yes, I.
Yes.
I'll,
Jago to us again.
my lord, I just, in a very lighter,
Asa. Kali se disclaimer regularization like people. Take it out. I really didn't know what to bet. It will be mentioned. It one I did one now. Yes.
yes. Now, the judgment, my lord, says that the 10 years also, I don't know, that's a constitutional bench judgment. These are two judges, Bikram Nath and Honorable Prasanna. But whether that particular judgment of 6 judges always, constitutional bench always will remain.
Mr. Kashyap, any judgments were cited from your side on the other day?
Multiple judgments were cited. One of them was Jago.
No, because I don't find any. Aru file ase nahi ki samajho? Yet to ek judgment nahi. Na it to again. Yet ki bar ase nahi.
My lord, the judgment.
Just 1 second. Let me just. Oh, it's there. It thaki was again Jago. Samajho. Next point. Yeah. Okay, my- I found this, I think only 4 judgments I find here, Mr. Kashyap. One is the Jharkhand Kamal Prasad, 2014-7, Nihal Singh, 2013-14, Karnataka Keshari, 2010-9. Then Narendra Kumar Tiwari, 2018-8, Vinod Kumar, 2024-9. Getting it?
Lordship.
And Upen Das, GLT 2020.
Lordship, in our case, the relevant
So
judgment.
these are the ones only I think you have given,
Along
right?
with them, a few more were there.
That you have not cited?
Lordship, we had cited, we had also circulated a
That
book
is-
list with them.
That is the list, I think. But those,
Maybe I could take it.
if you are relying, then I have to get those copies. That's why you are
Lordship,
relying on them, right?
Lordship, my senior is relying on them.
Okay.
However, Lordship, the most important judgments here would be Shirpal, which is 2025 SCC online ST.
एक मिनट दियो, list कौन दियो? I don't think any note has been given till now, na, Mr. Kashyap, from your side.
Lordship, note has not been given.
So
It's been some-
after you finish your reply, you want to give it?
Lordship, my senior was had instructed me for the respondent for my senior.
That's why I asked after reply,
After
because some note has to come.
Lordship,
So then
after
you
reply.
put all this in your notes.
Indeed, we'll do.
Okay.
There were some type of elections.
Yes.
My lord, all the judgments which were cited, I have gone through their judgment. I'll have to give a reply to those judgments. Sherpal, the last judgment of 2025, I'll show that.
Hmm.
Some
Why
type
don't
of,
you just, Mr. Nair, just put it in a note?
that's a,
That would be
Yes.
easier
Yes.
because you see, I generally want to hear and dictate in court,
Yeah.
but it will not happen today.
yes.
So it'll definitely go on another date, then I may forget.
But-
So you put.
Yes.
extract the paragraph.
However, Mr. Das, you want to say
No,
something?
no,
Please go ahead.
what I am saying is, my lord, we know now the facts, my lord. 2 writ petition, I'll just repeat that. 9474, one is a writ petition which they have filed. In 2019, there was an advertisement for filling up of 4 number of posts. They participated. 1, 2, and 3, they were not qualified. 1 and 2 was over age. 3 did not have the minimum cutoff mark. So out. 4 and 5, petitioner, they doesn't have the requisite qualification. So on this ground, when they became unsuccessful, they came to the court by filing the first writ petition. Their first writ contention is, please regularize our service. Because we have put on more than a decade, so our services should be regularized. This was the case. And the advertisement should go. That was the case in the first. Affidavit were filed. In the meantime, my lord, the candidates who appeared, so far as pursuant to the advertisement, they were selected and they were appointed. Once they were appointed, my lord, they filed the second writ petition 938 of 2020. Now that challenge again based was similar. It's saying that our services should be regularized and those appointments they have put to challenge. The appointments were made. Now 6/2/2019,
You want water?
no, thank you.
Yes.
My lord, on January 2020, we discontinued in the month of December itself, December 2019. But there was some order passed by.
90 or 20? Oh,
No, there was some order.
that's
passed
why
by the
till
court.
20 they got the
Till
sample.
20, we have given a fresh appointment. But that appointment is continued till 31/3/2020 because of the court's order.
Mhm.
In the meantime, there is an order passed by the court. They will continue till the regular selected candidates are not being appointed. In the meantime, we appointed.
They have been appointed.
So on 6/2/2020, we decided to terminate their contract.
Yes.
We were paying the salary till 31/3/2020.
Right.
That's the case, my lord.
Very well. This is
And-
there in that page 3
Yes.
of yours.
Yes.
Yes.
Now, my lord, these 2 cases come before this court and all the affidavit has been exchanged.
Yes.
Now, our contention, one is that your initial entry was academic counselor. There is no such academic counselor as such. Because at that relevant time, we had a rule the Assam Education Service Rule 1962, my lord.
Hmm.
61, 82.
82, I
Yes,
think.
kindly see that rule.
Are we having the same book?
Yes.
Which
Yes, same
page?
book, page 703. Page 702 it start. The Assam Education Service.
70?
The
Yes, I have
702.
it. I have it.
702.
Yes.
Kindly see the method of recruitment, my lord.
Yes. Academic qualification? No.
Yes, method of section 5, top. Method of recruitment.
Yes.
At page 702.
Yes.
I have not come across any post like academic counselor.
Yes.
No post of academic counselor.
Yes.
So now, let us say, my lord, your lordship will think that decade, going by some judgment of the Supreme Court, why not to regularize the services? But you have to see the initial appointment. Your initial appointment, or your lordship has seen, initially in some of the department, contractually they are appointed. But they have got requisite qualification. It is not that there's a, because government said that no, we contractually they will have. Now even contractually appointed teachers are being also continued, but till age of 16. They are regular teacher also. But some benefits they are not getting it. But they have the qualification. It's not that they doesn't have the qualification. And there has to be a vacant sanction post. So my argument, what I want to advance, is that when the advertise was issued, who has issued the advertise? Your lordship knows all these are true in APSC. These are not by
APSC.
Not by an APSC. So even then, if your lordship want to regularize, let us say one, even then, greatest respect, my lord, it will be difficult to regularize the service. Because initial entry into service is academic counselor. We don't find any academic counselor in the rules. But now, my lord, in some cases we see that selection doesn't take place. But some vacant sanction post, qualification they have got, put in some years of service, and even then court considers that they have qualification. They have put in 10 years of service, is a sanctioned post. So let their services should be considered 20 years, 25 years services. But here there will be some difficulty in considering their case. One is the biggest obstacle which I find is that the regulation taken by the executive council, where in 2018 they decided not to regularize the service of all the contractual. They mentioned Cotton College State University. It merged with Cotton College, Cotton University. It has been spelled out. You did not challenge it. Secondly, you did not have, second point, you did not have these particular under the rules also not been appointed. And kindly note down in rule 6.
Direct recruitment.
Yes.
To the commission.
To the commission. Kindly see, my lord. Direct recruitment of post.
So this rules 5 and 6 that you referred here is of this, isn't it?
Yes.
Okay, got it.
Yes.
All right.
So this is what you don't conform to the
Very well,
those
Mr.
requirements. And if your lordship, for a moment, I just trouble your lordship to 938.
Yes.
See page 60, 29, kindly see.
Page?
Page 29.
Yeah, that 19208.
Yes, kindly see this.
Yes.
Application along with all necessary documents are invited for the interest candidate. Academic council ad hoc in the Department of Computer Science and IT.
MSc, MTech, MCA in computer science.
So no minimum 55% mark, no net slate. If you don't have a net slate, you should have PhD. You don't have all the requirement. So, my lord, I am asking myself, can the court regularize the service? Even then, for a moment, let us say that you did not challenge that also. The decision taken by the council. But even then, where is that? So,
No, perhaps the argument was to the effect that it may not be regular, but at the same time, it's not illegal. It is irregular.
These are two.
I think that distinction perhaps
lord,
was,
Irregular and regular. Irregular can be regularized, illegal cannot be.
so
that's what I'm understanding.
correct. According to them, this is not illegal.
These may be
Um,
irregular, which can be regularized. But who will regularize? To some extent, the regularization has to be in consonant with some provision of the statute which has been laid down.
When the initial
what I'm
entry
saying.
is
Yes, initial.
bereft of the requisite qualification.
Yes, that's what I am saying, my lord. You have a qualification, absolutely no problem. Some test was not held, it was not to an advertisement. Then also your case
Okay.
may be considered.
Okay.
So this is
Noted.
yes. Yes. Now, my lord, the selection, the selection has to be held through you. The UGC selection, there are some regulation has been laid down. They have to go through that process. They have not gone through that process also.
Yes. All right.
Right, my lord? Now.
Only thing that regulation you give, huh?
Yes.
Yes.
And in pursuance to this advertisement at page 29, this is of 2008, and Lordship, again I am repeating it. 2007, some other was appointed. Petition number 1. Petition number 1. Yes, appointed. But Lordship, kindly see, 2008, this is advertisement of 2008.
Where?
2008. Page 29.
Yes.
We only found record so far as this advertisement is concerned.
This
And
of
there is one
2008.
advertisement.
So basically 7 is not backed by any advertisement.
Yes.
So that is one goes.
Yes.
That's what you're trying to
Yes,
distinguish, isn't
yes,
it?
Yes,
Okay.
yes. As well as others also.
No, when
We do not have
otherwise,
any
I mean,
records. We do not have any
individually, when you say 1, there is no advertisement
Yes.
at all.
records. Yes,
Some advertisement for 8.
yeah. And other minor, we do not have records of others, my lord. So
But this 2008, this one you have record, isn't
This
it?
we have 29.
29?
Yes, but they relied, we don't have. They
You don't
relied.
have that record.
Yes,
But you have the record of some selection process,
Yes.
which is that,
there are an affidavit we have filed.
so that is pursuant to what advertisement?
That is
That's
not
to
for
the-
any of the petitioners. That was only of one Mr.
Those that Dushan
Yes.
and that Biswajit who
Biswajit
didn't
also
qualify,
participated.
who did not
Yes.
qualify.
Not qualified.
If your lordship kindly note down.
All right,
this is the
I understand.
115 page. 115
Uh,
of our affidavit which you have.
what is there?
115 is the application. It is
For
invited,
applications.
that was invited at page 115.
Okay,
And that in pursuance to that, one Dushan Datta was appointed.
Dushan, this is
Yes.
Dushan.
Vishwajit Das also,
Okay,
also was participant.
I
but-
have taken note of
Yes,
that.
that's, you find at 115 and
Very well,
116.
very well.
We don't have, let us say very honestly, we don't have any other records
That's all right.
to that.
Yes, anything else?
Yes, now this is. the
I'm
case.
only trying to, I'm being mindful that this
No, no,
matter,
that's- I will-
no, not because of that, but you see today, otherwise I'm taking up CB1. And
Yes.
this is not from CB1, so it's unfair for all those
No,
civil
right.
matters.
This is
So,
a case
Yes,
that whether the court will regularize the service, because in absence of any of the lordship has seen, we are not backed by any statute. Maybe you are not backed by statute even then you don't have the requisite qualification at that time. 2015, 17, 18, you were qualified, race 2 was not qualified. Why they joined together and they file one writ petition, that is also questionable.
okay.
They could not have.
That clubbing also you are saying.
So how they can club? They
7,
only
8,
put
9.
the, because 2 doesn't have, he doesn't have that qualification also.
All
They
right.
have club.
All right.
So, and my lord will kindly note down,
Yes,
the advertisement which has been issued, one is unreserved. If you see that advertisement,
which one? 29?
the advertisement of 2019,
That is at,
if you see at 938, there is
Yes.
petition.
yes,
See the advertisement on 938 at page 63, my lord. See that 63?
no, but they did not get it anything. They don't want about that advertisement
No, even
otherwise.
then, they participated, they did not participate, they were out.
So I
if you
don't
see
think
at
we need to
page
go to that.
65 also,
Yes,
65.
Yes. 65.
65 is the post. Advertise. Assistant 65. 63 is staff.
Yes.
Serial number 10.
Yes, one
This is-
SC, one UR, one UWS, one
Only one is
SCH.
unreserved. One is unreserved. All the petitioner are unreserved.
These are academic level.
Yes.
Yes.
So this is our
Okay.
case, my lord. And secondly, the judgment which my learned friend has cited, one judgment of this High Court by learned Singh coordinate bench, that is WPC 5304 of 2021. If your lordship is holding that, I don't know. This is what they,
Upendas.
this is Rafiqul Islam.
No, this is not
Nine
given
eight.
to me.
You know, DDS, Rafiqul Islam.
This
Yes,
is
he will-
not part of
He will
the.
hand over. But that was, I noted down, and that was this is not to Rafiqul Islam.
I don't think so. It's not even in this list.
Huh?
They are taken to night.
But you have shown that. Yeah.
I don't think, Mr. Das. I
We
don't,
do not have it in our records.
I don't think they've relied.
There is what?
I don't
Paragraph
think of it.
4 and 6.
Yeah, I
He also
remember.
doesn't have it, Mr. Dyer.
I always normally.
You know, I sometimes, I understand that you all burn a lot of midnight oil, thinking what is going to come from the other side. I think you all thought this has been given.
I just wrote down all the judgments.
Anyway,
Because these judgments important because relied and stretch on. the judgment.
give.
So it is only partial, Your Lordship, the copy that I have.
So then perhaps you must have relied because Mr. Das has taken a note of it. Yes, Mr. Das.
See paragraph 4, my lord. Paragraph 4.
Yes.
Considering both the aspects, the only option remained for the petitioner would be regularized in the service. Petitioner may have been appointed on a contractual basis initially, but a contractual appointment is always understood to be for a given period of time, as time is always the essence contract. Continuation of more than 14 years till they do not indicate that is the essence of time in the engagement of petition. Be that as it may, petitioner is stated to be working against a sanctioned vacant post, and he has served more than.
I
14
now remember I asked whether this post is sanctioned or not after seeing
Right,
this.
That's the.
I remember.
That's the
Yeah.
point, my lord. Even if you go by spirit of the law laid down
Yes.
by Supreme Court in.
I think I
No.
asked Mr. Gogoi. I had asked you also this question that day, isn't it?
My lord will kindly see the last word, Uma Devi, what it says. Even if you go by spirit, kindly see last 3 lines. Even we go,
Yes.
this is a judgment which I am referring.
In Jagu, which was the paragraph?
Yes. Your go. Paragraph 8.
Okay, sorry, I have it.
Yes.
8, 9, 10, 19, 20, 26, 27, and 28.
Yes.
Yes.
So my lord, if your lordship now goes again back to Rafiqul.
Yes.
Kindly
Rafiq or
see-
Uma Devi?
Yeah, Uma Devi, a legal right has accrued. See,
Yes.
my lord, Uma Devi, legal right is accrued to the petitioner for being considered to be regularized in his.
Against the sanction post.
Yes. If you see.
I
last-
remember this.
Yes.
Yes.
Now, my lord, kindly see 8, paragraph 8 of the last paragraph.
I saw
Is the
sanction
lordship
post.
see?
I
Yes,
see.
yes.
Against the
This is-
sanction post.
Yes. So this is a judgment which he relies. Sripal. Sripal again. Yes, right.
Yes, Shripal.
Yes. That's it. Your lordship got a Sripal?
Yes.
Your lordship is holding Sripal?
Yes.
Yes.
Just give me the paragraph.
Yes. 8, 9. Is 8, 9, 14, 15, 16, 17 and 18.
Yes.
I'll not trouble by reading all these are the
Okay.
law proposition which has been laid. down.
Yes.
This is Sripal and Joggo I have already. And there are other
In
cases.
Jagu, I think they were relying in para 18.
Yes.
Right, Mr. Kaishap? Para 18, right, of Jagu?
18 and 20.
18 and?
20.
Okay. Yes.
And they relied one judgment, Jharkhand, state of Jharkhand versus Kamal Prasad. 2014.
Yes, para 30. Para 30 they relied.
Para.
Yes,
Please see para 3 of that. Facts is important.
para 3. Yes, read.
3. I'll just read the 3. Respond employs the writ petitioner before the High Court were initially appointed in the year 1981 in the post of junior engineers in the Rural Development Department in the erstwhile state of Bihar, in respect of which the recommendation of Bihar Public Service Commission for short BPSC was not required. It is a case of the respondent employee that they have continuously discharged the duties in the above post honestly and diligently to the satisfaction of the employee. They were subsequently appointed on ad hoc temporary basis as assistant engineer in the pay scale of so and so with certain condition on the basis of recommendation made by Bihar Public Service Commission against temporary post from the date of notification. Their services assistant engineer on ad hoc basis were entrusted work in so and so where they were required to contribute so and so. So ultimately, their recommendation is by Bihar Public Service Commission. So they have gone through a particular channel.
Okay.
For junior engineer, it was not required. This is the case. So facts is important to connect the law. Man.
Yes. Precedents are only contextual.
Yes. And I will give the judgment which we relied. I will not just waste the time. This is a judgment in different details. Please look into this judgment.
You are not going to waste the time of the court.
No, just
but it's just the judicial time is also precious.
Also, all my colleagues are sitting behind
Yes,
my back.
yes.
See all the judgments. We'll
Very
give a
well.
copy to my learned friends.
Yes.
Copy to them. And a copy.
এখানে
Wait.
এইকেইটা judgment-ৰ
এই copy.
এইকেইটা লৈ পেলাই তাতে একেলগে কৰাই দিব না আপুনি হা কমলক পঠাই লাইব্ৰেৰীৰ পৰা আনি তাতেই বনাই দিব এইটো দিটা আছে respondent number
4 and 5.
4 and
Scotland University.
4 and 5.
Hello, what we will do it. I'll ask my learned friend to make a facts your lordship knows to make a note on the judgment which we cited. What is a judgment
Correct,
they
correct.
cite? How we
Very
distinguish
well.
the judgment?
Very well. Very well. That would be helpful.
Yes,
Very
we'll do it. I think that's all, my lord.
Very well. Yes, Mr. Gogoi.
My learned friend is saying the remarks can be read. I said, no, I will not read these
The remarks.
remarks which he made in a column.
Ah.
Judgment, we kindly see that remarks. He made lovely remarks.
Yes, I saw.
Yes,
I saw.
so which paragraph?
I've seen
Yeah.
contents, no.
Contents, yes.
Points, please.
Yes,
Points,
I've
yes,
seen.
points. If the remarks were not there, then of course I could have. Remarks is there.
No, no, I saw.
Yes.
When you said remarks, so I got little, but the details of the, when you have put the note, I've seen. Very detailed. Yes,
If any clarification is required.
very
my
well.
lordship will
Very well.
grant.
Because the matter is not getting close, so
Yes.
anything on the next date, I shall.
My learned friend, Mr. Kostov.
Yes, Mr. Gogoi.
With your lordship permission.
Yes, please. How much time will you take, Mr. Gogoi? How much time will you take?
15 to 20 minutes.
Okay. Because I have the whole list to start.
Otherwise, if difficulties, I can other day also. Otherwise, I am ready also.
Perhaps, I don't know why this matter is, otherwise for a hearing matter, it should have been on a hearing date. No, we can also have it posted on Thursday for your reply.
Thursday, let's say next, let's say on 27 onwards, one NDLB matter is day-to-day hearing will be taken in court number 1, Lordship.
Okay.
Otherwise, I can finish it up 20 minutes, Lordship. Before that also.
Because today apparently I also have to join the division bench once the DB1 rises. So only for that, because it's already 11:30, 1 hour I have already given to this matter.
Then also as per my lord's convenience, otherwise I have no difficulty.
So as it is, the petitioner is not going to reply today.
Yes.
So on keeping that in mind, since you already know what this court wants, so perhaps you must be having the records, right? There's no record.
Because we are not engaging at any point of
So
time.
just have a little kind of a note
Lordship.
ready so that on the next date you can sum it up and take me through a note. That could be also helpful.
That's
A little bit like a pointer or something, not needed.
That's why I give the
detail.
pointer, even what is the law at the relevant
Correct,
point of time.
correct.
And
So
that's
just
when-
give that
that's when
on the
the
next
employer
date and
petition-
you say whatever you want to say. So when do you want it?
Lordship, if I may, it may be listed on 11th of November, your lordship.
Yes. Heard Mr. T. Kashyap, learned counsel for the petitioner. Also heard Mr. D. Das, learned counsel. Learned senior counsel assisted by Mr. P. D. Nayak, learned counsel appearing for the respondent number 4 and 5. Also heard Mr. Also known and Mr. K. Gogoi, learned, you're appearing as
Standing Council Higher Education.
learned standing counsel, higher education, so and so for the state respondent. Your name? B Saha for respondent numbers 789. Mr. D. Das, learned senior counsel, completed his argument on behalf of the respondent number 4 and 5. Relist on such and such date for further hearing.
20,
Lordship,
20, or 20, any day.
Lordship, I would like to suggest the date, your lordship, on the 11th or 13th, your lordship.
11, 13, I have difficulties, Lordship. I will be out of station, Lordship.
I too, my lord, 11th.
So another date.
Then lordship,
20th, my lord.
Because see, Mr. Gogoi has to reply, so the date has to be
Then 20,
convenient to Mr. Gogoi as well.
20 or Lordship. I have
27th November.
Lordship,
Sort it out.
Someone should pay to buy slip for a device, yeah, huh? The part heard invitation लिख दिया यार लगा देखिए ये तो बेलक के लिखा ना ये लगे इनका पता है ये तो बेलक ना कोनो लेकिन
Item number 3 and 4, Mr. Didas is not engaged by now.
In item number,
Yeah.
so there only your name.
Only my name.
3 are 4 out of contact. Okay, fine.
3 and 4 methods are मतलब बाहर का tool parent department, different department.
Particular.
So you are also appearing,
Yes, sir.
Mr.
We are along with my next that मतलब with control.
Okay, fine. Yes.
Deep.
Item 8 and 9.
Lordship, can I pay for some time, Lordship? Mr. TJ Mohanta will appear in this matter.
All right.
Item 10.
Restoration. Restoration and no one there. Then appears on call, relist after 3 weeks in a date to be fixed by the registry.
Item 11.
Yeah, Nibo, yeah, Nibo.
Maybe the lordship.
Yes.
If your
Compensation not given.
Lordship, this is not the case, Lordship. Compensation we had already released. The case is, Lordship, that after getting an order from this honorable court, they have filed a suit seeking more compensation. So in that suit, we have filed an application under Order 711 saying that the suit is barred by limitation.
Suit is barred by
Barred by
limitation. But this revision petition you have filed,
Lordship,
challenging which order?
challenging the order dated
Page 73.
Page 73, your lordship will find.
7/125.
Page 73,
Yes.
7/125. Yes,
We filed an Order 7 application, Order 7 Rule 11 application for rejection of the plaint.
rejection of claim.
Plaint.
Yes.
That was, our case was rejected.
So
lordship.
that was rejected.
Yes. It's arranging that order, lordship, we have.
They have the plaintiff.
They are the plaintiff, lordship.
So against that order you have come.
Lordship.
What is the material irregularity?
Lordship,
What is the patent error?
our specific plea was that, lordship, the suit was required to be filed within 3 years. And I'll start from the plain, lordship.
1 second. I want to know what is the ground, what is the error? You see, this is a civil revision petition.
Lordship.
This is not an appeal. This is not a on facts. You have to point out the error.
Lordship, here the case is based on facts because
Fact
here
we
the-
will go, but what is the error? There must be some ground of our filing. I am only wanting to know the ground, Mr. Counsel. What is the ground? Because I find a detailed order has been filed.
that your lordship will find
Paragraph,
70.
I also come to para 79, page 79. Read from the above provision. You are Mr. Bora, right?
Yes, lordship.
Yes, Bora, read
From the
from,
above provisions of law as well as the judgment of the Honorable Apex Court, it is seen that section 14 of the Limitation Act will be applicable if the earlier proceedings and subsequent proceedings relate to the same issue, and the prior proceedings has been prosecuted with due diligence and in good faith. In the instance suit, the victim died on 10/4/2018. The plaintiffs approached the High Court by way of writ petition seeking compensation, and the High Court, by the order dated 18/5/2023, granted compensation amount of ₹4 lakhs to the plaintiffs, along with interest, and further gave liberty to the plaintiffs to pursue other appropriate remedy available under the law for further compensation. Under such circumstances, it is evident that the plaintiffs had approached the Honorable Guwahati High Court with due diligence and in good faith, and the matter before the High Court as well as before this court relate to the same matter in issue, and therefore Article 14 of the Limitation Act gets attracted. Now, that is the issue, lordship. Article 14 is not attracted in this particular case because High Court is not the court wherein it does not have jurisdiction.
no, that's the wrong court.
Lordship.
But nonetheless, the matter really, the same matter was pending there. You see, anyway, we'll go into that.
Okay.
The proceedings before the High Court was completed by the order dated so and so. The instant suit has been filed on immediately, which is within period of limitation.
That-
Yes, limitation এখন দিব দে। So your ground.
My contention is that, lordship, the writ petition was filed on 18/5.
No, that I have understood. What I'm asking you is that your primary ground for in your petition for rejecting the plaint is that it was barred by limitation.
Limitation.
That is your primary ground. Okay. Now let's quickly turn to order 7. That's nothing about limitation. That নাথাকিব বুলি কৈছে নে? এইখিনি যোনখিনি মানে বুঝা এইকেইটা মানে তোমাৰ বেঞ্চ ওৱান আছে মেইন এইখন এগুলো হয়ে থাকে
Order 7 Rule 11D, lordship.
1 second. People side here. That's all. Do we check? Cutting up.
এখানে এই
Nothing is repeated.
That's the limitation.
Yes, Lord.
Order 7 rule.
11D, that your lordship will find in the CPC.
Yes, I have found it. 11D, na? Where the suit
appears to
appears
be
on them that may be barred by any law.
Any law,
So under that you had come.
Lordship.
Okay. Now from here, 14, exclusion of time of proceeding, bona fide in court without jurisdiction. Yes.
Lordship,
Yes, this High Court did not have jurisdiction, but they were bona fidely believing it has jurisdiction, they were following it. And this is a discretion. The
E-
court has exercised the discretion.
even
What
if-
is wrong in it?
even admitting that
Mr. Counsel, even if suppose two views is applicable in revision jurisdiction, you want this court to upset it. You have to point out the error of law, Mr. Bora.
Lordship may
You see, Mr.
understand.
Bora, you have to be mindful which
Lordship.
jurisdiction now you are before. This is a revision jurisdiction.
Lordship.
So you have to show me that there is a jurisdictional error, there is a law error. That is not the case. It's an exercise of discretion. You see, Article 14 is clear. You cannot now say that because the matter was being proceeded in High Court, Article 14 will not come in. Even if you are making that argument, I'm going to reject that argument.
Lordship, even
Because without reading Article 14, you see the caption. What does the caption say? Please read it out. What does the caption say?
there are 4 conditions.
No. Only the heading.
Yeah.
What does the heading say, Mr.
Exclusion
Bora?
of time proceeding bona fide in court without jurisdiction.
In court?
Without jurisdiction.
So what have you been arguing, Mr. Bora? That the
Even-
High Court does not
Have
have jurisdiction?
No, that is my case. I said that High Court has jurisdiction to enter in this, to grant
See,
compensation.
even if it has the jurisdiction, however, the High Court rejected it on ground of what?
The High Court said that you are entitled for 4 lakhs only. Therefore, the plaintiff now cannot file a suit saying that,
So are you saying res judicata then?
yes. Not only the res judicata, if your lordship kindly.
No.
Even admitting, if I may.
Because
make
you've
my
been
submission.
using the word wrong court. Why did you use the word wrong court then?
Not exactly wrong court.
No. You see, didn't you use that word?
Lordship,
You used it or not?
lordship.
So that is why I am now getting little. I'll take it on another date. You look into it. You decide what is your course of argument going to be. Because you are saying wrong court. Now you're saying it is the right court. So you another date, Mr. Bora.
Lordship may keep it as a part of.
No, part
Because. lordship,
Wednesday.
Lordship,
Wednesday.
lordship, even admitting that.
As
Article
prayed for
14 is
Wednesday.
applicable.
Yes, next. You look into it. You because you said wrong court, I was going into a different
Article
direction.
14 is not the
Yes,
only.
next.
Lordship, my argument is.
All right,
only
Mr.
on-
Bora.
Lordship.
I'll hear you on Wednesday. Come fully prepared. Yes.
Item 40, supplementary list.
Wait, please, your lordship. Your lordship, the main issue was that the gross salary, from the gross salary of the deceased, income tax deduction was not adjusted while computing the loss of dependency. That is the main issue.
Oh, put this gold. Let him go. Yes.
Your lordship, the main issue was that the gross salary of the deceased, that which was 37,791.
This is
And
a MAC appeal.
Yes, your lordship. From that amount, income tax deduction ought to have been adjusted while computing the loss of dependency. That was not done.
What has the only challenges?
Your lordship, that is not the only challenge, but
No,
the main
but
challenge.
what did you said? Main
The gross salary of the deceased. The deceased was
the
a
gross
salary of the deceased.
salary
Of the deceased was considered.
of the deceased was
Considered while computing the.
this is considered.
Yes, your lordship.
Yes.
While computing the loss of dependence.
Yes.
And income tax deduction ought to have been adjusted from that amount.
IT.
Yes, your lordship.
You are for whom?
I am for the insurance company.
That's why I was getting confused. I thought you were for the claimant. So I said, why are you saying it's considered then?
Otherwise, your
So
lordship,
IT ought to have been deducted.
yes, your lordship.
Who's for the other side?
My pleasure, lordship.
You are for the claimant.
Yes, lordship.
So only that part you're challenging, or?
Yes, and another, your lordship, the interest part.
So this
from-
appeal is today for admission.
Yes, your lordship.
So it's not admitted till now. It's a statutory appeal. Statutory
Today-
deposits have been done.
Yes, your lordship. We are ready to deposit 50% of the awarded amount. And they may be allowed to.
On first deposit, lordship may be released to the claimant. This is 19.
Let them deposit, subject to deposit. I'll stay you're seeking a stay, isn't
Yes.
it? And you must have already given the 25.
25,000 we have deposited.
That statutory deposit you
yes,
have already given.
yes.
That apart,
That apart, this 50% of the awarded sum, we are ready to
yeah,
deposit.
they are ready to give.
Yes.
Okay. Heard Mr. S. Datta, Learned Counsel appearing for the appellant. Also heard Mr.
And they're not lordship.
and Devnath, Learned Counsel appearing for the
Respondent number 1 and 2. lordship.
only two respondents.
Yes, claimants.
Uh,
Five of the deceased,
respond,
one of the dead.
4 respondents are there. Your lordship.
but you are appearing for
Claimants, lordship. Wife of the
respondent number
deceased,
1 and 2.
1 and 2 year.
The other, what about 3 and 4 has been deleted or what? Has been
no, your
struck.
lordship. 3 and 4 will take fresh test.
No, it says 5, 25 in so and so. The names of 3 and 4 have been struck off.
Your lordship may be in the condonation of delay.
Huh?
There was a delay of
No, Mr. In the appeal, it was struck. Like you said. But there
your
is a,
lordship in delay means
I'm not in the delay. In the MAC appeal, are they there or not? 3 and 4.
your lordship, I believe they are not there because I think they have been
Fine.
back off.
Okay, fine. Your name?
And
Nikhila?
Devnath, lordship.
Nikhila? For 1 and 2. This appeal is presented under section 173 of the MV Act 1988 against the judgment and award dated 31/10/2022 passed by the 11th member Motor Accident Claims Tribunal number 2 Kamrup M in MAC case number 720 of 2019. The requisite statutory deposit has been deposited before the registry of this court. Admit notice, no, Mr. So-and-so accepts notice on behalf of 1 and 2. Notice by registered, it appears that the respondent number 3 and 4 has already been struck off by this court by order dated 5/5/25 in IAC number 2474 of 2023. Extra copies is given.
We will provide
Extra
them.
copies in the course of the day or 2 days Korea. 2 days, no, 3 days Korea, Friday and hun. Then you say that subject to payment of subject to 50% payment of the awarded amount, the so and so judgment shall remain state until pending adjudication of the so and so. Yes.
Your lordship, then I is for stay, I number 1736 of 2025.
So then that I get disposed of.
Yes, your lordship.
I can say in view of this only disposed of, or should I? I it separately to deal.
Similar order.
And that is at that upon proper verification before the registry, the same shall be released.
Much of.
I disposed of. Right?
Item 41.
Lordship. Lordship, we prefer the appeal on the ground of quantum only, my lord.
The first time,
Yes, sir. Yeah, not first time, my lord, delay, first time delay, my lord. Delay was already condoned.
no, correct, but this
See, first time, my lord.
exactly. So it needs to be admitted, isn't it?
Yes, my lord.
This is a MAC appeal.
Yes, ma'am.
Okay. Statutory deposits have been given.
We
Oh, yeah, the insurance.
I am for the insurance. my lord.
MAC appeal, এটা Terry Kora.
50% limit number 1 can be allowed.
You want a stay?
50%, my lord.
Now, are you seeking for a stay?
Yes, ma'am.
Where is the IA? So main case of admit code was statutory deposit. All respondents, Mr. Bhatta, na? A.R. Agarwal. So respondent A.R. Agarwal, our ticketer naam to Luluba. Same diba, aru IA to subject to 50%, the same order, huh? Disposed. IA disposed of. Yes.
Claimant to number 1 may kindly be allowed to withdraw the.
That I am not saying. I said claimant, so upon verification, proper verification.
In
No,
item
that is
number
to mention,
42, my lord,
Huh?
the name of, my name is not
that
on
is
my
to
lord, in
order-
post list, my.
One second.
For
Yeah.
that to deposit to the registry and the claimant may.
Registry, and then I said claimant.
Claimant may kindly be allowed. to-
Yes, yes, I have already said it.
Yes, sir.
Yes.
In
In-
item number 42, my lord, my name is not shown, my lord. That's why, my lord, I am not.
But 42 will be also same.
Same lordship.
Same.
Then
Their appeal, lordship.
you don't want the stay today.
No, my lord.
Okay, then 42 you want an adjournment.
Yes, my lord.
Yes. The Monday lordship.
42 after a week on a date to be fixed by the registry.
Lordship, one date may kindly. fix
Yes,
by the
next.
lordship.
Item 13.
Yes. Item.
In this case, the form is one suit, two appeal has been preferred here. One has been admitted. And similar question of law may be, substantial question of law may.
You have that order. You have that order.
Yes, yes.
And in this, where otherwise, Mr. Dasgupta, where is the substantial questions of law you have given in the memorandum of appeal? Where do I find it? Yes, page 3.
So no, I am not pressing all these things, right? So-
You want that?
I must. To solve my purpose. Only thing is the issue number, there is a mistake.
Can you ask a junior to just correct it there?
Well, let me correct it. It should be 13.
Same order you want. Okay, 4 weeks. Same.
There's stay petition, right?
And the stay petition, their stay was given.
Not.
The same order here also. What order was given there?
No, stay, so called.
Notice is issued in the stay.
No order already.
I'm issuing notice in your stay.
Plus, all right, that will, application is listed.
Correct.
Monday. That is application.
You want that stay to be listed on Monday?
No. Yes, that.
No, but that I'm issuing notice.
All.
Is yet 9 ki stay khon yet aha nai 30 not. I said to akon I
I say, I.
396.
396 of 2024.
A order to a yet hobo. Everything remains same. Party name mane achai loba. Our stay ekhon ase that just notice issue korai diba 4 weeks. Returnable 4 weeks.
Sorry. Item 14.
It's for a personal photo timing also.
Yes. Wednesday?
That's it.
Wednesday.
Personal photo timing also.
And do it next week also will find because of the fact that.
Okay. Relist Monday. Yes.
Lordship, date will be-
Next.
Lordship, date will be difficult for us after 15 November.
Okay. Next.
28.
Yes.
16, 4 orders.
Last time also there was no appearance. None appears for the petitioner on call. It appears that on the last occasion, I 29/8/2025 as well, there was no representation on behalf of the petitioner. It further appears that the names of 4 councils, I DD 1, 2, 3, 4, is reflected in the cause list. However, despite the names being reflected in the cause list and the matter being posted today for orders, there is no representation. Relist on such and such date with intimation to the learned counsels appearing for the petitioner by the registry and no, stop on such and such.
Item 16.
None appears for petitioner on call. It was same, it appears on the last 2 consecutive dates, i.e. 35/25 and 29/8/2025, despite the name of MSF Ahmed. Baki same.
Item 17.
None appears for the applicants. None appears for the applicants on call. It appears that on the last occasion, I-13/8/2020, no, Taragodya, Mr. KK Bhattacharjee, learned counsel, is present for the respondent state. It appears that on the last occasion, on 13/8/2025 as well, there has been no representation on behalf of the applicant. The instant application, I'm dismissing it. Take your seat. This application is filed for restoration of the CRP number 203/2013 under Article 227, filed for equal restoration, which was dismissed for non-prosecution by this court by order dated 16/2/18. It is with utmost dissatisfaction, this court pens down that despite the present application being filed for restoration of the civil revision petition, which was dismissed earlier for non-prosecution, is also being very casually attended by the learned counsel appearing in the matter, inasmuch as on the last 2 consecutive on the last 3 occasions, including today, there has been no representation on behalf of the applicant to press the instant application. Be it as it may, the I stands dismissed for non-prosecution.
Item 18.
At least, your lordship, here in this case, the service upon the respondents has been completed, but as far as the service upon the respondent number 1.4, that is Godavari Devi Goel. Your lordship, this Godavari Goel has been expired. Your
So
lordship,
you have to do probably
your lordship, what had happened on the last order, if your lordship may go through the last order, the respondent has pleaded that they want to strike off the name of this Godavari Devi Goel.
respondent
1.4, your lordship.
Details of respondent number 1.4, that is Godavari Devi Goyal, are already on record.
So you are the original plaintiff.
Yes.
So you are not going to, have you taken any steps for striking off their names?
Lordship, Lordship, in the Lavazima court, when the matter came that we have submitted one application that all the legal years of Godavari.
That I have understood, but are already parties here.
Yes, sir.
So then I think we can proceed.
Yes, Lord.
They are already represented
Yes,
by you.
Yes, Lord.
Where is that note? Heard, Mr.
A Sancheti, my lord.
A so and so, learned counsel for the petitioner, also heard MS. T. Agarwal, learned counsel, appearing for the respondent numbers.
All the response.
No, not all. You're not appearing for 14,
All-
for 1.4. So you're appearing for which respondents?
1, 1, 1, 2, 1, 3, and 1, 5. 1,
Respondent numbers 1.1.
1.2, 1.3, and 1.5.
Correct. It appears that the respondent number 1.4 has already expired and all her legal heirs are already on record. Hence, the name of the respondent number 1.4 maybe is struck off, stands struck off. Let a fresh cost title be submitted to the registry for doing the needful. A relist after 2 weeks on a date to be fixed by the registry.
Okay.
Item 19.
Yes.
Yeah, please, Your Honor. I'm for the appellant, Your Honor.
Yes. Why is this for orders?
Your Honor,
Why is this matter for orders? Steps, what happened?
LCR, Your Honor, has received.
Huh?
LCR has been received, Your Honor.
Sorry?
LCR has been received, Your Honor.
Huh. But what about respondents? You are for?
I'm for respondent number 1, your lord.
What about respondent number 2? What happened up to 2? Notice served, not served.
Notice has been served, Your Honor.
Huh?
Notice has been served, Your Honor.
Where is the proof? Have you seen the office note?
Your Honor, it has been.
Have you seen the office note or not?
No, Your Honor.
Then on what basis are you saying notice has been served? On what basis are you saying notice has been served, Mr. Counsel? You will not find it in your file. You will not file anything in that file to the any answers to the query that is being put to you. You should have opened the court's file, see the office note, verified whether that notice has been served or not before you make a statement before this court that the notice has been served.
If I'm not mistaken, Lordship.
Anyway, yes, you want to say something?
Lordship, if I'm not mistaken, it has been Lordship mentioned in the last order, Lordship.
You are right. So that has been served. Office note is not them, but it's shown. I think you have filed an affidavit. So say that you have taken dusty service because that registered post there is a finding that AD cards have not come back. Why are you not saying that? Huh? Because you have taken by alternative mode. Yes. All right. TCR Rahisani. Heard, Mr.
M. Boro for R. Ali.
M.
Boro.
Boro. Learned counsel appearing for the petitioner. Also heard, Mr.
S. Diffusa, Your Lord.
S.
S. Diffusa.
S what?
Diffusa.
Diffusa.
Yes.
Learned counsel appearing for the respondent number 1. It appears that though notice has been served upon respondent number 2, however, none appears on call. It further appears that the trial court records have been received. List for admission. In the usual course. Sorry. Yes.
Item 21.
Yes, Mr. Das.
There's an office note dated 16/8/2025. Then attempt was made to serve notice upon all the respondents by way of a registered post as well as usual process. I've gone through the office note, my lord. It shows that my lord, service upon respondent number 8 is not completed.
All right. Await service in respect of respondent number 8. Relist after 2 weeks.
My lord.
On a date to be fixed by the registry.
I look.
22.
Yes. Why is this for orders?
Together, I informed that my lord, question number 1 is died, my lord.
Yes.
Sole respondent, Lordship.
Yes, Mr. Chakraborty.
What happened, I have two difficulties. The appellant is a company, they are on the verge of transfer.
You want some time?
I want some time.
All right.
And second thing is, Lordship, one of my person from the garden has informed me, he has given me one name of the son. He has.
That I'll verify, my
but
lord.
that
About
was-
the legal years, my lord.
More legal years are there.
So then you all
yeah,
verify.
that you can
You see,
verify-
because I don't think I need to put all this
Oh,
on
yes, yes.
record.
Otherwise, my lord. it has
Mr.
already approved.
S. Chakraborty, S. No?
Yes.
S. Chakraborty Learned Counsel for the heard Mr. S. Chakraborty Learned Counsel for the appellant, as well as Mr. P. Sundi
Yes.
Learned Counsel for the respondent number 1. Mr. S. Chakraborty seeks for the 2 weeks time to do the needful in order to bring the legal heir of the respondent number 1, if the right to sue survives, on record. Prayer is allowed, relist after 3 weeks. 3 weeks on a date to be fixed by the registry. Mr. P. Sundi the office of Mr. P. Sundi shall also extend all cooperation in this regard to Mr. S. Chakraborty so as to find out the details of the legal heirs of so and so, if any.
Much better.
23.
Your service complete, my lord. in terms of-
Complete.
Documents-
Records आहे से नहीं
What is not record, lordship, it is simple matter, 46.
My friend
No, but records was called,
No record,
not called. Na?
not it is not record also.
So, but then now service is complete for admission. Heard Mr. A.I. Uddin, na? Uddin Learned Counsel appearing for the petitioner, also heard
BK
Mr.
Bhagavati.
B.
BK.
K. Bhagavati, Learned Counsel appearing for the sole respondent. In view of the service being completed, list this matter for admission when next week? Next week on any date to be fixed by the registry. Interim, if any, shall continue till the next date of listing.
24.
Very unusual. This is again, I think, a restoration. What are they seeking? Restoration.
Lordship, and with the respondent, Lordship, respondent 1.
I
2,
reckon kiba heri ase ni. I don't know. One second. Just 1 second. Itu kiman matila? 24. None appears for the petitioner on call. You are appearing for?
Lordship, respondent 1, 1A, 1B, 1C, 1D, and respondent 3 and 4. Lordship, in this case, respondent number 2 died, Lordship, and her legal heir already, in this case, Lordship, respondent 3 and 4, Lordship.
MS B. Barua. No, sorry. MS
R. Dev appearing on
R?
behalf of heir shown. R. Dev.
Deb. R. Deb, Learned Counsel is present on behalf of is present for the respondent numbers 1,
1A,
1A,
1A, 1B,
1B,
and 1D,
1C,
and 1D,
and 1D,
and 3 and 4.
and 3 and 4. She further of though office of Donokopa, it appears that though the notice in respect of respondent number 2, as per the office note dated 22/5/2025, is received by the relatives. However, there is no representation on behalf of respondent number 2 on call. Today on call. However, MS so-and-so informs the court that in the meantime, respondent number 2 expired, and her, he or her, R2
Her,
and her legal heirs are already on
in this case.
record. Who are the legal heirs?
Respondent number 3 and 4, Lordship.
I 3 and 4. relist after 3 weeks on any date to be fixed by the registry. So service is complete bili koi diba and relist after so and so for admission on any date to be fixed by the registry. Yes.
25.
He ordered to member side him, huh? None appears on behalf of the petitioner on call. It appears that on the last two occasions, i.e. 23/8/2023 and 21/4/2025 as well, there has been no representation on behalf of the petitioner on call. The instant application is filed under section 24, read with section 151 of CPC, praying for transfer of title suit matrimonial number 210 of 2022 pending before the Learned Court of Additional District Judge FTC number 2 Tinsukia to the Learned Court of the District and Session Judge Jorhat. In view of the consecutive non-appearance of the respondent petitioner on the last 3 occasions, the transfer petition stands dismissed on being for non-prosecution. Yes.
Item 28.
Disposed of date.
May I please, the Lordship? I am appearing on behalf of B. Fukan Lordship.
Yes. Yes. Some difficulty today.
Yes, Lordship.
All right. As prayed for by Mr.
B. Fukan Lordship.
No, you are not Bifukan.
Yes, Lord. I am P.K. Gogoi Lordship.
As prayed for by Mr. P.K.
Gogoi.
Gogoi. Relist after 2 weeks on a date to be fixed by the registry. Learned counsel for the petitioner will go.
I live.
Yes.
Item 30 and 31.
You want to withdraw the suit?
As per office noted, 36.
Service is not complete.
No, sir.
Await service.
Okay.
Relist after 3 weeks on a date to be fixed by the registry.
31 is
31 also same?
same.
Okay.
Neither ID card nor answer notice has been received.
Await service. Okay.
That's it.
Yes.
Item 32.
Yes.
As per office note dated 26/9/2024, ought to have been 26/9/2025, Your Lordship. It has been stated that by the register has come unserved, Your Lordship. And by usual process, no specific address has been stated. But
You want to take fresh?
yes, Your Lordship.
As prayed for by Mr.
J. Das.
J. Das, Learned Counsel, appearing for the petitioner. The matter stands adjourned for 3 weeks to enable so-and-so counsel to take fresh steps as prayed for in respect of respondent number 3.
Intend to continue.
Interim, if any, shall continue to the next date of hearing, next of listing, and MS
R. Gogoi.
R. Gogoi, Learned Counsel, is present for respondent number
1 and 2.
1 and 2.
Deeply obliged, Lord.
Item 33.
Yes, why is it for orders, Mr. Chaudhary?
Lordship, as for the office note, we are supposed to take steps upon respondent number 1 to 4.
Have you taken?
I am referring to the office note dated 14/7/2025, Lordship. In this case, one person had appeared for the respondent number 4. The council appeared for the respondent number 4. Thereafter, again, I have been this order has been passed to take fresh steps upon all the respondents. So today I have taken steps. But one thing I just want to point out is that on 2023, I have taken steps upon all the respondents. Prior to that, also I took steps. But since 2023 and the office note is of 2025, the receipt, the money, the consignment receipt is there. They have already tagged this consignment slip. But the fact is the tracking record is not there because of after 2 years, it has been checked and accordingly the tracking record is not there. Pursuant to that, I have been directed to take fresh steps. So in that view of the matter, Lordship, there is some difficulty because we are taking steps.
No, but you have taken today.
Today I have taken steps.
So then I'll record that and let's.
Earlier also I took steps, Lordship.
No, but you see, Mr. Chaudhary, you have taken steps today.
Yes.
And that is as per these orders. So.
Prior to that also. I could
All
say
right,
yes, Lord, but the thing is
heard,
that it was not-
Mr.
Yes,
SP Chaudhary, na?
Yes, Lord.
Learned Counsel appearing for the petitioner. Mr. Chaudhary submits that in terms of the earlier orders passed by this court, fresh steps in respect of respondent number
1, 2, 3 and 4.
1, 2,
3 and 4.
3 and 4 has been taken today.
Yes.
Relist in view of the aforesaid, relist after 3 weeks on a date to be fixed by the registry with up-to-date status report. Service
The
report.
interim order is there.
Interim if any shall continue till the next date of listing. Yes, next.
34.
Yes, why is this for orders?
I am for the.
So they have
Notice-
appeared now.
Notice was issued.
So
I am here.
service is complete
Service is complete.
and it can be posted for admission.
Yes, my lord.
Interim is also there.
Yes, my lord. Stays there, my lord.
Any records have been called? Not required. Okay, heard Mr.
Yes, for us.
S. Parashar, learned counsel for the petitioner, also heard Mr.
Yes, Islam.
S. Islam, learned counsel appearing for the sole respondent. In view of the appearance of the learned counsel, so and so on behalf of the sole respondent, service stands complete. List for admission when
Second week of
in
November.
on any in the month of after 3 weeks on any date to be fixed by the registry. Interim, if any, shall continue till the next date of listing. Yes, 35. অলপ পিছত মাতি দিব আৰ্টছ মাতি দিব পাৰে এইটো ডিছপ'জ হৈ যাব yes মাতা Mr. Mahanto, your matter, I think, time being.
Yes.
Lordship, in this case, Lordship, respondent number 7 and 8 died. We could not collect the address, Lordship.
My lord,
So we
that
could
is not the
collect-
material here right now. Your lordship kindly.
No, that's what I was thinking. If only that was the thing, then Mr. Mahanto would not have been sitting there so long. Yes, yes, yes. What? No, but Mr. Roy, you are for the you are the applicant.
Yes, your
My
Lordship.
lord,
And this application is for what?
Coordination of delay, Lordship, our civil revision petition has been dismissed, Lordship.
You are filed this application for condonation.
Yes.
How much delay?
Lordship, as per
yeah, lord.
How much delay?
Lordship here, Lordship. Lordship 8.
And the steps of now, Mr. Mahanta, you are appearing for?
I'm not that, my lord.
No, but you are appearing for?
I'm in that case, I'm in that, I'm appearing, my lord.
No, in this IA, you are appearing or not?
Yes, Lordship.
Because there is the IA has come today.
Lordship.
That your lordship kindly, for the timing, you kindly set aside there.
Mr. Mohando, I will, but you see, Mr. Mohando, what is on board today is this IA 3947.
Yes, your Lord.
That is on board. And
Yes.
with that, of course, the civil revision is there. Now,
No.
and
There
with
are
that,
two
there are
cases.
2 other IAs also.
My lord.
So now, as far as IA 3947 is concerned, this is for condonation.
Lordship is setting aside order dated 12/11/2018 passed in CRP 119 whereby my CRP has been dismissed. Lordship.
So that you are,
Want to file a restoration of that.
how much delay?
Lordship 288 days.
200?
88 days.
88 days. And why this has, the steps have been not complete?
Not complete, Lordship.
Why?
6 and 7 has died. We could not collect the legal heirs of 6 and 7, Lordship.
Their performance.
But nonetheless, they are parties.
No.
And now, Mr. Mohanto, you are in which IA? 2134.
Yes, my lord.
What is that IA for?
I am, my lord, dear lordship, kindly, what is the crux of the matter is this? I am a decree holder. I got the decree in 2011 and till today I am unable to execute because of they are playing fraud with the court, my lord. One by one, my lord. If your lordship allow, I mean, even right now I can prove it, my lord. What happened in this case, my lord? I got a decree. I file an execution case. In execution case, they file an application that it will not be binding on me because we are not that person. We have not received notice. But learned trial court make a finding that they are the same person. They have received the notice and that order is challenged before this honorable court.
Now, if for some reason this court finds that the delay condonation has
that is
no
good.
merit,
My lord.
and dismisses it, then your IA will survive.
No, my lord, that is next matter, my lord.
That is,
There are
No,
two
but-
matter, my lord. They are filing, why they are filing two application, I do not know. There are two civil division filed before this honorable court.
Oh, there are two civil revisions. So
My lord,
y-
they are, my lord, I just placed their
okay,
notice appointing,
okay.
my lord.
So your IA is in the civil revision 99.
99, I filed an
And
application.
this civil revision which was dismissed is 119.
Yes,
Is 119.
so I am in now 99, my lord,
Okay.
99.
No,
but today's lordship CR
Both
3946
no, all are there.
All are
As far as IA 3947 is concerned, that is completely different.
My lord,
A to some, 2134 IA to some.
Because vacating CO.
long back I have filed in 2018.
Now you want, what is your prayer here?
My lord, my prayer is to, my lord, vacate the interim order passed by this honorable court.
Where is that interim order?
Interim order page, my lord, 12. IA page 12,
2418.
my lord.
Yes, please place the interim order.
2/4/2018, my lord.
Yes, please place it, page 12.
Page 12, yes. Heard Mr. P. Sundi, learned counsel for the petitioner, that Sundi submitted that although the two order has been passed impugn in the proceeding, yet is passing the challenging against the order dated 17/3/2018 along with the present petition. Accordingly, Mr. Sundi, the decree which was passed in the suit where petitioners were not made party in a being a sought to be by execution of their land, and by the impugned order dated 17/3/2018, the learned executive court had dismissed in limine in application filed by the petitioner under the order 21 rule 26(1) and section 151 CFA without the discussing the clear terms that the issuing relating the dismissal and the father's name recommended so submit that if the decree is allowed to be executed, then the same would be lead to the serious miscarriage of justice in respect of the client under the circumstance on the other protecting interest of the petitioners has been paid for. But notice returnable 2/6/2018 step by registrar post AD service of the notice upon the respondent to be taken into the today the edition service of the notice on the stay to be protect so the registry in this court is the petition of the so and so has also been under taking the note of the submission of the petitioner counsel. It is hereby provided that till the returnable date of further proceeding, the execution case number 12 of 2000 is pending in the court of London Civil Judge Nagaon still remains state. So that was
Mr. Mahanta, are you carrying that decision of the Supreme Court which says that execution proceedings should not be delayed? You have that? Please ask your junior to find it out, because I might just allow this right away. So I want that decision. Yes, because this stay order is of 2018.
18, my lord.
So
And my lord, no, what
your
happened, my lord?
execution has been pending since when?
2011, my lord. Decree of 2011, my lord.
2011 is the decree.
Decree and the execution case, title execution case number 12 of 2011.
Which is stayed by this order.
By this. And my lord, what is their case, my lord? You must kindly see the main order, my lord.
Wait, 1 second.
My lord, sorry.
Go slow, Mr.
my-
Mahanta. Please give me that decision. Find out in your mobile, Mr. Mahanta,
Yes. Sorry, my lord.
or at 2.
Or at 2, my lord. That will be better.
Find that decision.
My lord.
Lordship, let it be taken up on Monday.
No.
Monday next,
No, no.
Lordship.
Get me that decision. Execution proceeding. This is not a joke. 2011 and execution proceeding is pending. And the revision petition, which has been already dismissed, you said it is similar.
What happened, my lord? They have filed two applications before the court, if I am not wrong, my lord. One is, my lord, before the executing court, they have filed two petitions, my lord. One is for in limine to dismiss the petition. In limine, my lord, that execution proceeding had been dismissed. Probably that was dismissed for default. And there, again, here also that is against the file, my lord, that is also dismissed for default.
Is it?
Lordship dismissed for default in wrong presumption, Lordship. That's stated
So
that
just
law.
give me those those particular
My lord,
orders.
then everything, my lord, because
Let
they are
him
now, what we are making, they are trying to, my lord,
I just want to see all that.
all this, my lord, then your lordship kindly keep it part of Monday on Monday, my lord,
Monday.
and everything. I'll-
Monday, I may be in the division bench. Monday and Tuesday, there may be a special division
But any
bench.
date, my lord, next week,
But
my lord.
next week, Lordship, I have,
I'll
Wednesday.
give a
Lordship,
details, my
Wednesday.
lord.
Lordship,
My
Wednesday.
Okay, Wednesday.
My lord, that will be better, my lord.
Lord.
And all, I'll all along with all judgment, my lord.
Lordship.
Okay. Yes.
My
On
lord.
Monday, Lordship.
29. 39. Okay, no, my lord.
Wednesday.
Wednesday, keep it part of, my lord, I know.
Wednesday will come.
Item 36.
কোনখনৰ পৰা? এইখনে না?
May it please your
এইটো
lordship.
as prayed for কৰি Wednesday কৰি দিব। Yes.
Parent office for dated 17/10/2025. Your lordship, as regards respondent number 1 and 2 services completed, your lordship. Your lordship, this I is for condoning delay of 68 days in filing the appeal, your lordship.
So you are for 1 and 2,
No, lordship, only one.
but 2 is also served.
Yes, your lordship. Respondent number 2 is the owner.
Yes. What is the ground?
Lordship, a delay has been explained in para number 2, your lordship.
Any objection? 68
No,
days delay.
No.
Yes. Para?
Para number 2, your lordship, in page number 4.
Okay. Your name?
P. Bodhapur.
Heard MSP Borthakur, Learned Counsel appearing for the applicant. Also heard MS SP Das, Learned Counsel appearing on behalf of respondent number 1. Though office note dated 17/10/2025 indicates that service in respect of respondent number 2 has been completed. However, there is no representation on behalf of respondent number 2 on today on call. Be that as it may, the application is being proceeded. The present application is filed under Section 5 of the Limitation Act so and so for condoning the delay of 68 days in preferring the connected appeal under Section 30 of the Employees Compensation Act 1923 against the judgment and order dated 29/1/2024 passed by the Learned Commissioner for Employees Compensation, Borpeta, in EC case number so and so. The grounds of delay as pleaded in the condonation application reads as under paragraph 2, 3, and 4. MS so and so does not object to the prayer for condonation. Upon hearing the parties and perusal of the aforesaid grounds as extracted herein above, this court finds that the grounds stated are sufficient and bona fide. The grounds for condoning the delay of 68 days that has occurred in filing the connected appeal. But delay condoned, allowed.
Obliged.
Is the MFA registered?
Lordship, it's not registered.
I think it kiman number, sir? I think it's already registered. Registered na FA? No.
This is
Not
filing
reg-
number.
Let the in view of so and so, let the MFA be connected so and so be registered and listed accordingly.
Item 37.
Yes, how many days?
Your lordship, 63 days.
63 days. Mr. Bora, are you objecting? 60?
63 days, your lordship.
It has decreased by 5 days. 63 days. This naam gita ekye dekhi diba. Paragraph numbers?
4 and 5.
Slowly, Miss Counsel, no hurry. 3, 4, and 5.
Yes,
3,
your
4, and
lordship,
5.
3 to 5.
You see, when you have an opposing counsel like Mr. Bora, you need not open your brief. Huh? This is the kind of assistance generally a bench should always want from the bar, because you all are ultimately the officers of the court. Paragraph 3?
3 to 5.
3 to 5. Yes, allowed. Same baki can you?
Much obliged, your lordship.
Yes.
And addition is to be required that the main appeal is to be numbered.
I've given it.
Okay.
Everything what I have already dictated in that other one will be here.
Obviously.
I've already said. Yes. Yes, how many days, Mr. Datta? Huh?
37.
It's coming further down. But yours, I think, first time.
First time.
Mhm. So then notice has to go?
Yes, madam.
All right, notice.
Apply.
3 weeks, 2 weeks.
3 weeks, madam.
Steps by registered post?
Registered post. Apply.
Yes. 3 days, huh? Registered. Yes.
Supplementary list, item 43.
Yes, what is this? Yes, Mr. Agarwal,
This is for condonation of delay 45 days, Lordship.
45 days.
Yes, Lordship.
Notice has been, huh?
It is issued already, Lordship, and
Huh?
respondent insurance company also appeared, Lordship.
Okay,
And-
so then I can, 45 days.
Yes, Lordship. May kindly be condoned, Lordship.
Heard Mr. A.R. Agarwal, Learned Counsel appearing for the applicant.
Applicant claimant.
Claimant. None appears for the respondent on call. This is an application under Section 5 of Limitation Act 1963 for condonation of delay of 45 days in preferring MAC appeal against the impugned judgment and order dated 19/7/2023 passed by learned member MACT number 1 Kamrup M Guwahati.
MCT Gwalpara, Lordship.
MACT
Gwalpara.
Gwalpara.
Yeah, post title is even amended, Lordship.
আচ্ছা এটা চাই ল'বা হা সেই তাতো একটু চাই ল'বা ক্যাপশনটো
Flag number A is there, Lordship. Flag A. Flag A is there, they corrected, Lordship.
yes correct ইয়াতে আছে flag 8 হা এইটো চাই ল'বা and also heard তেওঁৰ নামটো দি দিবা দেই
SP son.
not objecting না আৰু yes paragraphs
3, 4, 5, Lordship.
three, 4 and 5 বাকি same registration and everything will remain disposed of the
Item 44.
yes this is also condonation Mr. Goswami
Yes, Lord.
how many days huh
Delay of Lordship.
you don't know
I know, sir. So it's what has happened, Lordship, in this case, a review petition was filed. And from the date
No,
of disposal
because the
of the
delay
review-
has suddenly increased. That is why you went to review petition.
Yes.
I was wondering why are you not specifying the number of delay?
The actual delay is Lordship 80 days.
2,465.
Yes.
Hmm.
Lordship, but the actual delay is 80 days from the date of review petition.
Nobody is
So the-
appearing.
Dear Lordship.
Yes, huh? You Chakrabarti.
Yes, Lordship.
Name is shown.
Name is shown.
No, name is not shown. Oh, shown.
Day before yesterday, she was there, Lordship.
Okay, which paragraph?
Paragraph Lordship 3.
What is the ground?
Ground Lordship, since the appeal was the
Just 1 second. পাৰিবা নহয় এটা চেঞ্জ কৰিব লাগে নেকি yes what is the ground because this is quite a lot of delay 2,465
ground of
the
appeal. Lordship-
explanation has to be sufficient and bona fide
Yes, Lordship, already review petition, Lordship, since the appeal has been filed on 17 and 23,
Hmm.
it would appear, Lordship, that there is a delay of 2,465 days in filing this appeal.
Hmm.
But from the date when the review order was passed on 27/22, there is a delay of 80 days,
All
Lordship.
right, since the other side has not appeared today, I'll take it up on another date.
Fair,
Heard Mr. R. Goswami, Learned Counsel appearing for the applicant. None appears for the respondent on call. Relist next week on any date to be fixed by the
Yes.
registry.
How long, Lordship?
Item 35.
None appears for the applicant on call. Relist after 3 weeks on a date to be fixed by the registry. Someone should. Come on, someone. এইখিনি এনেকে ৰাখিবা হা? এইকেইটা ইয়াত আৰু
Equity.